Yes, well, good afternoon. Very nice to meet you all. My name's Alison Williams and I'm a barrister at Harcourt Chambers. I'm 17 years qual and I currently specialise in children law. And as part of my responsibility to Chambers, I'm Vice Chair of our Pupillage Committee. So if you apply to us, I'll be one of the people who are sifting your Pupillage Gateway applications. I was going to tell you a little bit about my journey into law and family law, the types of cases I deal with and why I think it's such an interesting area to practice, and then a little bit about the skills and qualities that you need, in my view, to be a good family law barrister. I'm sure my colleagues will have lots of other maybe contradictory tips and advice. So in terms of my journey into law, I took what was back in 2003-2004 a fairly conventional route into the profession. I did an undergraduate degree in history, then the law conversion course, then I did my bar training. I went straight into pupillage at Harcourt and have been there ever since. I say it was a fairly conventional route because nowadays I'm seeing that lots of our pupillage candidates have far more diverse and probably interesting routes into the profession, and there's no such thing as a typical route into the bar anymore. We get a number of applications from candidates who've had other careers. For example, last year we had a number of teachers applying for pupillage, those who'd previously worked in the city. We had a social worker apply for pupillage, and certainly in my chambers we've got members, one of whom used to work in the police force, a couple who've worked in business before transferring to the bar, somebody who worked in the civil service, and a couple of people who've worked in academia, indeed one who still does and manages that with his career as a barrister. A significant number of pupillage candidates as well, rather than do and go straight through from academic training to the pupillage. A number of our pupils and pupillage candidates spent time working in solicitors' firms as paralegals, they've been judicial assistants, or had other jobs to further their skills they need to be a good barrister. And all of this can be really helpful in terms of building your transferable skills, in my view. That's not to say we don't have candidates who apply to us for pupillage straight from their final year at university or their law conversion course. And my advice is always, the earliest you can start applying for Pupillage Gateway, just do it to get to practice. You may not be successful in getting pupillage in your first year of trying. That really doesn't matter. We've interviewed and taken on as pupils candidates who applied to us 2 or 3 on their second or third attempt, and they've used that experience to build on their CV and build on their skills. So my point really, there's no typical or conventional route into the profession anymore, and don't worry about if you've not studied family law at university, that really doesn't matter. So in terms of why I chose the bar and family law, firstly I did history at university because I was interested in it, so that's the point I decided to do what I was interested in, but law was always at the back of my mind as a profession to go into. Particularly my mother always used to tell me I was very good at arguing, so I'd be a good barrister. But I initially thought about being a solicitor. I was attracted at that stage by the more financial security, having a contract, etc. But having spent 3 weeks in the height of the summer sitting in the commercial litigation department of a city solicitor's firm, and the associate I was shadowing with didn't leave the office once in those 3 weeks, that put me firmly off commercial law and indeed being a solicitor. So I then considered the bar. The number of uni pupillage is in common law set, so a variety of areas. But what I was particularly interested in was area of the bar where I could do a high level of advocacy work in court and a high level of client advisory work, and family law in particular stood out for me. And then on the law conversion course, I wrote my extended essay on family law, the interpretation and application of the welfare principle. I found that by far the most interesting area that I had studied. And essentially the reason why I liked family law is that it's all about people. There's a huge amount of client contact. And we're dealing on a day-to-day basis with people who are going through some considerable challenges in their family life. It's a real cliche, but I think it's true. The advice and guidance and representation you give clients as a family law barrister gives you an opportunity to make a considerable difference to people's lives. And your clients are always going to remember who you are and what you did for them. And no family or family law case is the same. There's a huge variety of the types of families and family law problems that we encounter, and it engages all aspects, I think, of the human condition, whether it be cultural, religious, medical. For example, last week I was learning all about sickle cell anemia and the management of that for a care case. Next week I've got a case involving quite complex psychological evidence regarding the child in that particular case. We learn all about things which you wouldn't necessarily come across, I think, in other areas of law, and there's very rarely a dull day, I think. So I started off my career at Harcourt by doing the full range of family law, children and finance. I did do some civil law as well at the start of my career. That was actually quite a good grounding in drafting, opinion writing and learning about applying procedural rules. But I dropped that after a few years to focus on being a specialist family practitioner. And I decided to specialise in children later on, as I felt I enjoyed that area of law the most. But I do think it's a good start, and I encourage my pupils to experience the full range of family law, because even if you go on to specialise in children, you need to have a solid understanding of how matrimonial finance, what the law is, how it operates. So when you're talking to a client in a private law children case, if they're also going through financial remedy proceedings, you can understand the background to that and answer any questions that they've got. So majority of my work at the moment is public law children. It can represent local authorities, parents, family members, children themselves to their guardians, in cases where local authorities are applying for care orders and supervision orders, where children are at risk of suffering significant harm or have suffered significant harm. And those cases may well involve adoption or special guardianship orders or permanent removal of those children from the family. So it's serious stuff that we are arguing about. Final hearings are often multi-days. You could be 3 days, 5 days, 10 days. We often do fact-finding hearings, which are to establish the causation of injuries, for example, to a child, who caused them, by whom. There could be urgent hearings and case management directions hearings, where you're making tactical decisions on the evidence you require to get the case in shape for a fact-finding hearing or a final hearing. And public law children really encompasses a huge range of issues, including non-accidental injury. I've done cases involving fabricated and induced illness, clients who've got issues with drug abuse, mental health issues, domestic violence, neglect, learning disabilities. So there's a huge variety in the types of clients you're going to be representing. You'll be 1 week representing a parent who's got high-level learning needs. The next week you're representing a local authority and you've got a professional social work client, and that brings with it its own challenges. And then with private law children, that's disputes about care and contact arrangements with parents who have separated. And again, you have a huge variety in the types of client, their background, their circumstances, what they want for their children, and it gives you. It's very interesting to get involved in that area as well, I think. In terms of the skills, I think you need, and certainly ones that we look for in my chambers, excellent academic ability is really important, and ability to think analytically. You'll often be asked to absorb and process huge amounts of complex and detailed information and extract the most relevant parts from that. So, for example, next week, my final hearing starting on Monday bundles well over 1,000 pages, including a 50-page psychological assessment. So one of the key skills of a family law barrister is to be able to read it and process it very quickly and find the most relevant information to build a case for your client. So always make sure when you do your application forms, you bring out your academic and analytical skills and how you can do that to form a argument. We also look for excellent advocacy and communication skills and being able to form a strong logical argument regardless of your own perspective. Quite often, whether it's private law children or public law children, you'll be asked to put forward an argument on behalf of your client that you don't personally agree with, or you may even find morally fairly reprehensible, but your duty is to your client to advise them and to put forward that argument. And particularly in public law children, you may be representing clients who've been accused of doing some pretty awful things, but you still have to be able to deliver a strong and confident argument on their behalf. In terms of delivery, you need to make sure you can adapt it to the audience. As a family lawyer, you could be in front of magistrates, a district judge, circuit judge, High Court judge, or your career's going that direction, Court of Appeal and the Supreme Court. And it's very different advocacy styles depending upon the tribunal you're in front of. And then in terms of your clients, you're going to one day be advising a client who's highly intelligent, runs their own business, etc., on their private law children case. Next week, you're advising a very vulnerable mother with learning disabilities. There's a very different way of communicating with those different types of clients. So excellent communication skills are a must as well. And finally, strong interpersonal skills, which you've got to be able to connect with your client, to establish a rapport so that they can trust you and trust your advice, most importantly. You've got to be able to negotiate with your opponent and adapt your approach depending upon that opponent's negotiation style. And then, of course, you've got to be able to connect with your tribunal and the judge. And you'll find that some approaches land differently depending upon which tribunal you're in front of. So strong interpersonal skills are key, really. So when you make your pupillage application, have a think about all those skills and where you found them in other areas of your life, whether it's your academic studies, your legal work experience, your other work experience. Don't neglect things that you've done, like working in a bar, or we once had a candidate apply to us who worked on a building site, hadn't put that on his form, but actually he managed some really difficult situations on the building site, and that was one of the key things that stood out for us about his pupillage application. And when you draft your application, think of it as a part of written advocacy. So you were trying to demonstrate to the reader who is going to be sifting your form and deciding whether or not you come for a pupillage interview. You're trying to sell yourself as a good barrister and a good family law barrister. So think about how you can effectively argue your case as to why you should be given a pupillage or pupillage interview at that Chambers. I think I've had my 10 minutes now, so I will be quiet and hand over to my colleagues. Thank you.
I'm Oliver Wise from Queen Elizabeth Building, called in 1981. Alison, it seems to me, has demonstrated just what a barrister should do if they're going to present a case properly. They should be properly dressed, they should be properly prepared, they should have thought about what their audience needs to know, they should have researched the matter properly. And my only excuse for not being in the same position is that when I arrived at 5 to 12, thinking that I was just going to do the 1.5 hour slot there, I noticed that QEB to TBC was on the list in relation to those who were going to speak today. So I inquired of my fellow members of Chambers who it was going to be. Oh, we think it should be you, Oliver, which is why I am here today. And I suppose if there's any particular relevance in having before you somebody who has evidently not prepared what they're going to do, it is that is the sort of situation which you might be in still from time to time when you're doing cases as a young barrister. It's quite a long time since I was put in the position of being told, Mr. Wise, they always called us Mr. Wise in those days, many of the clerks do still to this day, Mr. Wise, you've got a brief at court in front of Mrs. Justice Butler Sloss. Now, some of you are likely to have heard of Mrs. Justice Butler Sloss. Probably you think of her as Baroness Butler Sloss, or Lady Justice Butler Sloss, or the first lady judge to go to the Court of Appeal. A very great figure indeed. Anyway, I didn't know what I was going to do when I turned up to court, so I went along with my notebook, feeling rather worried. Then the solicitor and client turned up, and it turned out that my client was a very anxious mother. We were in the High Court because the husband had disappeared with the child, didn't know where the child was, and I'd never done such a case. And so on the hoof, as it were, I had to decide what to do, and I thought, well, I must ask the court to make an order that the child be returned. I was so nervous that when I was handed the papers, I failed to observe the fact that it was the original affidavit which had been handed to me, and I started making notes on it. And then I realised that I had to hand this document, the most important document in the case, the piece of evidence on which we were asking the court to rely in order to make the order. And Mrs. Justice Butler Sloss asked why there were these notes written on the affidavit. And I said, I'm very sorry, my lady. I hadn't realised that this was the original rather than a copy, and I made notes on it. Anyway, she took pity on me and said, isn't what you want, Mr. Wise, a seek and find order? And I said, I'm very happy to be guided by your ladyship. And this illustrates the principle that really, if you're trying to do your best, judges tend to be a pretty nice lot. The solicitors and the clients tend to be appreciative if you're being as helpful as you can. And not only did Mrs. Justice Butler Sloss, as she then was, tell me what to do, she even advised me to go and talk to a very nice gentleman who was the tipstaff. That's the first time I'd met him. He's an important character, or perhaps she now, in that world. I can't remember. It's a long time since I've done such a case. And I suppose one of the things that the story indicates is that you need to have a degree of flexibility. You've got to be prepared to do things which you weren't expecting to do that morning. I think as you get more senior, you're very much less likely to be dispatched hither and thither. But it is remarkable how quickly the law can act. You hear about all these questions of the law's delays. I've been in front of a judge in a suburban county court asking for an order to deal with domestic violence which had taken place that very morning. It is amazing how quickly the courts can act, as well as how slowly they can. I don't know whether that's practical these days. I think it's an enormous disadvantage that legal aid isn't as available now as it used to be, which used to give people much more access to justice than applies. So, trying to look at what it is that I'm told I should be talking to you, why you chose the bar. Why did I choose the bar? I suppose as a small boy I was very interested in reading about trials. I loved reading brothers-in-law. I suppose the more contemporary thing is now looking at the various legal dramas. Don't cast an eye, if you will, over Talking Pictures TV. Now that's probably something you think only your grandparents would look at on the television, but it does have some wonderful old programmes like Justice, like Rumpole, and you get a feel for the history of the bar. Do bear in mind that even though this may seem remote to you, it's not so remote perhaps to the judges who were there, and so if you can produce a little crack from Rumpole or something, that may get the judge on your side. Why did I choose the relevant area of practice? Well, I didn't. In the old days, chambers were much more mixed and less specialist. My chambers was always very well known for doing family cases, but I went there because I understood it to be a mixed common law set, and I was going to go to Fountain Court commercial set for my second 6 months. In those days, it was such a different thing. You wrote to sets of chambers. They had far more pupilages than they do now. It's so intensely competitive. In those days, there were none or very few pupillage awards. And my heart goes out to people who have to apply for pupillage where the number of applicants so vastly exceeds the number of places. But I've been involved with the Pupillage Committee, first as committee's secretary in the late 1980s and early 90s, and I continue probably far too much of an old fart to this day. But it does give me a certain perspective, and it does tell me that it is still possible to make an unsuccessful application one year, come back with more experience, in a year or two. Do try and think what it is which is going to set you apart from the others when you're making your pupillage application. Do remember that it's not a question of people trying to fail you, because not everything has gone well, but you trying to impress them to think, well, there is something about this person which makes them at least worth interviewing. Maybe because they've got terrific academic success, maybe you weren't very successful with your undergraduate degree. Well, make sure you do jolly well with your postgraduate one. Or make sure that you've got some legal experience which is excellent. Or make sure that you have done something which pulls you out as being distinguished in some way. There are all sorts of ways that you can do it, and people aren't, when you're going through applications, of course, you can think, well, this person doesn't seem much cop because they can't string sentences together and because they haven't taken any trouble over proofreading or whatever, but generally they're thinking, oh, I do hope that something is going to leap out at me as being good by this particular in this particular way. What types of cases barristers in this area deal with? Alison's dealt with that very well. What do I find appealing about this area of practice? Money work is what I do mostly. I couldn't bear to do the same thing the whole time, so I also do negligence cases connected with matrimonial law, and it's nice to do some Inheritance Act stuff which is closely related to that. I also sit as a legal assessor to the Nursing and Midwifery Council, seeing fair play when nurses get into trouble. I do advise you not to try and do absolutely the whole thing the whole time. I think particularly in relation to such things as gruesome care work, I know of people who get pretty burnt out in relation to that well before the normal age for retirement. One of the things that there's more opportunity to do these days is to do judicial or quasi-judicial work. Get qualified as an arbitrator or as a mediator, but don't necessarily expect to get lots of work. I went to a society for mediation advocates seminar a few years ago, and we were addressed by the editor of the mediation magazine, who said the guilty secret about mediation is that the majority of people who qualify as mediators never get any work at all. So don't necessarily expect that it'll come your way, but look around for other things as well. Obviously, as a young barrister, you're going to want to impress chambers, you're going to want to build up your practice, but it's no bad thing to get some judicial, quasi-judicial advising tribunals experience on the way. What are the lifestyle implications of this area of practice? You've heard plenty, I'm sure, about barristers having to work extremely hard. I would say there's something to be said for going into a set of chambers where your lifestyle wishes are respected. I'm pleased to say that does apply in my chambers in Queen Elizabeth Building, and there are members of chambers who don't work full-time at the bar, even male members of chambers who don't work full-time at the bar. There's one of our number who is building up a good practice in mediation, arbitration, sitting as a deputy district judge, and he does much more than his wife does of the childcare. What key skills and personal qualities you think are needed to succeed in this area? I think you've got to try and be able to get on with people and see things from their point of view. Key skills, I would say, don't be a technophobe like me. It really is a good thing these days to be very skilled in terms of the computer, spreadsheets, and all that side of things. But don't reject reading law reports, seeing who the judges are in the law reports, knowing what the weekly law reports on the All England reports look like and what they have there, reading textbooks from time to time, knowing how to address judges. All these things may seem to be very unfashionable in the days of where everything is online and you would pick up a Kindle and not read a book. But you're dealing with lots of people who aren't like that, particularly judges, and it's quite a good thing to be able to get onto their wavelength. Right, I think I've spoken enough.